How to protect liquid assets. The benefit of having substantial liquid assets is clear: you have money that you can use whenever you need it. Liquid assets provide you with flexibility and mobility. However, liquid assets also come with significant risk, particularly if you fear being sued or are dealing with other legal threats. Asset protection trusts and family partnerships, or LLCs, are two vehicles you can use to protect your liquid assets in the United States. You also might consider converting non-exempt liquid assets into exempt assets, although you'll lose many of the benefits of keeping them liquid. Any of these options can be considered separately or combined to provide greater protection. Method 1: Setting up a protection trust. 1. Decide which trust is right for you. Asset protection trusts traditionally are established offshore. However, a number of states have passed laws that enable asset protection trusts to be created. These domestic asset protection trusts are subject to strict guidelines that vary by state. Offshore trusts can be tricky, particularly if you have no continual ties to the country where you set up the trust. Domestic asset protection trusts, however, can burn you if you choose the wrong state or don't set them up correctly. Some trusts must be irrevocable, while other states and countries allow you to set up a revocable trust that you can change or close at any time. Which type of trust you want, and the location where you want to establish your trust, will vary depending on your needs in protecting your assets. 2. Hire an experienced attorney. You can set up a basic living trust on your own, using forms and templates that are readily available online. Asset protection trusts, however, are governed by complex laws and regulations. The level of complexity means hiring an attorney is your best bet to ensure that your trust is established correctly to achieve the purpose for which it is intended. Depending on the type of trust you want to create, you may need to hire an attorney located in that state or country. A local attorney can help you determine if you need to hire somebody in the place where your trust will be established. If you already have a financial advisor, you may want to ask them if there are attorneys they recommend to help you set up an asset protection trust. They may be able to give you some names to get started. 3. Choose a trustee. Asset protection trusts often have an attorney or a finance professional who serves as the trustee. While in some cases you may be able to serve as trustee of your own trust, some state laws don't allow it. If you're establishing a domestic asset protection trust, the law in that state describes the person qualified to act as trustee. Often this person must have specific financial licenses or expertise. In many states, your trustee must be a resident of the state in which you establish the trust. This is often true for offshore trusts as well. Keep in mind that if you're able to serve as trustee of your own trust, it may no longer provide the same level of asset protection that it would if you had an independent trustee. 4. Draw up the trust documents. Asset protection trusts must include specific clauses and language to adequately protect the assets you hold in them. Your attorney will draft the documents for you and go through them to ensure you understand everything. In its most basic form, asset protection trust documents are similar to the documents required to establish any other trust. Your documents will contain language to establish the trust, identify the trustee, and list the assets included in the trust. You also must name beneficiaries of the trust. Typically, people name their children or grandchildren as beneficiaries of their trust. Keep in mind that if you protect your liquid assets using an asset protection trust, you will lose some access and control over the assets in the trust. 5. Execute your trust documents. Once your trust documents are finalized, you must sign them to create the trust. The execution formalities vary depending on where you've chosen to set up the trust. Typically, your signature must be notarized. you also may need additional witnesses. Depending on the location where you're establishing your trust, you may need to sign multiple copies of your trust documents. In some states, you may have to travel to the state to actually execute your trust documents and establish your trust. The same is true for some offshore trusts. 6. Transfer your assets into the trust. Once your trust is created, you must take all the liquid assets you want the trust to protect and transfer them into the name of the trust. This may require opening bank accounts in the name of the trust. If your trustee is a financial institution, they may create deposit accounts for your trust within their institution. Otherwise, you'll have to open an account in the name of the trust. This typically means you also must request an employer identification number, EIN, from the IRS for your trust. You can request an EIN free of charge online at the IRS's website by answering a few questions. The EIN for your trust will be issued immediately. In some states, the account in which you deposit the trust's liquid assets must be located within that state. This also is true for many offshore trusts. Method 2: Creating a family partnership or LLC. 1. Talk to other family members. To use a family partnership or LLC to protect your liquid assets, the entity you create should have more than one member. Otherwise, creditors may be able to seize assets held by the family partnership or LLC to satisfy your debts. You cannot form a partnership without at least one other partner. Therefore, you need to find a family member who also is interested in doing something to protect their liquid assets. You can create an LLC by yourself. However, generally your assets will be more protected if you have more than one member of your LLC. If a creditor wants to seize your assets from an LLC, they must first go to court and request an order. This process is designed to protect other members. For that reason, your assets may be more protected if you have at least one other member of your LLC. Keep in mind that if you create a family partnership or LLC and put your liquid assets into it, you no longer have claim to all of those assets. Rather, you only technically have title to your ownership share of the partnership or LLC as defined in your organizational documents. 2. Consult an attorney. Before you decide to use a family partnership or LLC to protect your liquid assets, it's a good idea to talk to an attorney about your plans. Laws vary by state, and the attorney can let you know whether your plans will adequately protect your assets. Keep in mind that you can't expect a family partnership or LLC to completely protect all of your liquid assets. There will still be a percentage share to which you're entitled, and creditors can seize those assets. However, they must first go through a legal process and get a court order to do so. Depending on the amount of liquid assets in the LLC to which you're entitled, they may decide the process isn't worth it. An attorney will be able to explain to you exactly how the law works in your state. If you describe how and why you want to protect your assets, the attorney can let you know if a family partnership or LLC would work for you. 3. Draft organizational documents. To legally form an LLC or family partnership, you must create documents that describe the organization, its legal name, and its members. The types of documents you must create vary among states. It isn't necessary to have an attorney draft your organizational documents. You can easily find forms and templates online that are designed to meet the requirements of each state. You'll have to choose a unique name for your LLC or family partnership. Typically, you can find a business name database on your state's website for the Secretary of State. For a small fee, you can reserve your name so nobody else takes it while you finish completing the documents and setting up your organization. 4. Sign organizational documents. Once your documents are complete, you and the other members of your LLC or family partnership must sign them before they have legal effect. Typically, your signatures must be notarized. You may have to sign multiple copies to file originals with different government departments. You also should make sure you have copies for each member of your family partnership or LLC. Check your state's formation laws to find out what formalities are required for signing. You typically can find these requirements on the Secretary of State's website or on the website of your state's Chamber of Commerce. If you're forming a family partnership, you typically won't have to follow the same formalities that you will if you form an LLC. However, you should consider completing similar organizational documents anyway for the security of your partnership's members. 5. Get an Employer Identification Number, EIN, from the IRS. You'll want to open bank accounts in the name of your family partnership or LLC to deposit your liquid assets. To do this, you must first request an EIN. Despite the name, you need an EIN for your family partnership or LLC regardless of whether it will have any employees. Rather, an EIN is similar to a social security number of an individual, and is the unique tax identification number for your LLC or family partnership. You'll need an EIN to open bank accounts in the name of your family partnership or LLC, which will be necessary to transfer your liquid assets into the organization. 6. Register your partnership or LLC with the state. Most states require you to register an LLC with the Secretary of State and file your organizational documents. Some states also require partnerships to register. Registering a partnership typically is voluntary. However, it may be in your best interests to go ahead and do it. You'll have to pay filing and registration fees when you register with your state. However, these fees are considerably cheaper than forming and registering a corporation, typically only a few $100s. Once you've registered your family partnership or LLC, you'll receive a certificate from the Secretary of State's office. You may need to present this certificate to open bank accounts in the name of the LLC or family partnership. 7. Transfer your assets to the partnership or LLC. Once all the formalities are complete and you've opened the bank accounts, all you have to do is deposit your liquid assets into the accounts owned by the partnership or LLC. Ideally, you should complete these transfers as quickly as possible after your organization is formed. Contact the financial institutions where your assets are being held to find out how you can transfer ownership of them. In some cases, you may be able to change ownership of the account rather than moving the assets to a different account. Method 3. Converting non-exempt assets. 1. Consult an attorney. Converting your liquid assets to shield them from creditors or others is not something you should take on by yourself. Laws vary significantly among states, and you don't want to risk a conversion that doesn't actually provide any protection. Keep in mind that assets that might be exempt in one state may not be exempt in another. To protect your liquid assets by converting them into exempt assets, make sure you comply with the laws both of the state where you have your primary residence and the state where the assets are located. If you describe to an attorney or financial professional how and why you want to protect your liquid assets, they can help you find the best way to do that. You also can find out from an attorney how much control and access you'll lose by converting your non-exempt liquid assets into exempt assets. 2. Identify conversions that best suit your needs. Converting some of your liquid assets into exempt assets may benefit you more than simply leaving them as they are. However, you need to make sure the benefits outweigh the losses. For example, you can use liquid assets to pay down a mortgage. This benefits you in that you won't have as many mortgage payments to make. However, you lose the flexibility that comes from having those liquid assets. While you may be able to gain more liquid assets by refinancing your home, this isn't necessarily a quick or easy thing to do. Life insurance policies and annuities also are exempt, but you lose significant control over those assets and won't be able to retrieve that money for a significant period of time. 3. Understand the limitations of converting liquid assets. The greatest benefit of liquid assets is that they are immediately available. Converting them to other assets may mean you lose access and control. For example, purchasing an exempt annuity or retirement plan may mean you lose complete access to that money. If you attempt to withdraw funds early, you may have to pay fees and have significant tax penalties. This may not be an issue if you don't anticipate having any reason to withdraw those funds anytime in the near future, but it's something you should understand before converting your liquid assets just to protect them. Converting non-exempt liquid assets into exempt assets typically is best for people who have no need for those assets in their lifetimes, and are saving them for the benefit of their children or grandchildren. 4. Use your liquid assets to purchase exempt assets. If you've chosen non-exempt assets you want to use to protect your liquid assets, all you have to do is purchase them to complete the conversion. Work with a financial advisor to decide which liquid assets you want to convert and how you want to complete that conversion. Depending on the reason you're converting your liquid assets, you also may need to pay attention to timing. Converting assets just before a divorce or before filing for bankruptcy may raise red flags in the court proceedings that follow. 5. Consider transferring assets to others. Another way to protect your liquid assets from possible seizure is to transfer them to someone else, such as a trusted friend or family member. Before you decide to do this, however, you need to understand the substantial risks involved. If you transfer assets into someone else's name, you lose complete control over those assets, regardless of any promises made. That person can take your liquid assets and do whatever they want with them, so you have to make sure you fully trust that person. Timing is a particular issue with transferring assets. If you plan to divorce or file bankruptcy within a year, or have already started either process, you should not attempt to transfer assets to someone else. Transfers that appear to have been made in anticipation of litigation will still be considered yours, and may result in a bankruptcy case being dismissed.